Look at some of the issues raised by Dr Nandipha Magudumana's application to the Free State High Court. I am now joined by Nthabiseng Dubazana, Director at Dubazana Attorneys. A very warm welcome to you, Mr. Dubazana. We appreciate your time here on SABC News.
Thank you so much for having me.
You're most welcome. Let's start by talking about the arguments or what is to be presented by both sides. And I think I want to start with what is being presented by Nandipha Magudumana. And I mean, on the surface, one could say that, it looks like it's a weak case, but, we know in the justice system, anything really can happen. And in fact, we've heard from the ministry, we've heard from Home Affairs where they've said, that her argument is fatally defective. One of the things that she is putting forward is the fact that she believes she was in fact abducted unlawfully and detained unlawfully. I mean, does it really matter at this point how she arrived in South Africa when there is a case at the end of the day to answer for? I mean, we're hearing of these alleged crimes, which some of them include, the defacing of a dead body or tampering with a dead body, pardon me. I mean, these are serious crimes that could have been, committed by Dr. Magudumana. So does it, in essence, matter how she was brought back here?
The answer is twofold to your question.
Yeah.
The first answer that is automatic would be yes. It does matter because it means that any evidence that was adduced to, put weight to her arrest after it was unlawful would be deemed to be unconstitutional. So there was a case many moons ago when we still had the interim constitution, wherein it was said by the Constitutional Court at that time that suspected persons are deemed to be arrested persons in terms of Section 35 of the Constitution. And therefore, anything that this person is suspected of doing, first, they have to be read their rights in terms of Section 35 of the Constitution. And as a result, any evidence that this person is going to bring forth in any manner or form then has to fall in line with Section 35.
Right.
So if her arrest was unlawful, it means everything else that follows, including the putting the charge to her, is going to be deemed as unconstitutional because her being brought before the court was not done in accordance with not only the Criminal Procedure Act, but also not in accordance with the Constitution. So the first part of that answer would be yes. It is important for us to know how her arrest was done. And now, if we establish that her arrest was done correctly, then everything else remains as is. But if we establish that her arrest was done incorrectly, therefore unlawful, it means that the charges that are put to her will therefore be deemed to be unlawful and unconstitutional, and therefore her arrests and everything that has happened so far will therefore be dismissed, for lack of a better term in that instance. All
right, let's flip it over then. Let's talk about what Home Affairs is then saying. They're saying, listen, we never arrested Magudumana in Tanzania in the first place. In fact, she was deported by Tanzania. In fact, not extradited. So how does that then sort of change things? I would assume in favor then of Home Affairs if they are going to emphasize the fact that, listen, we didn't actually get her extradited. It was an issue of deportation. They were not supposed to be there in the first place. How does that change things?
I had the privilege of reading the replying affidavit, the answering affidavit of Home Affairs.
Sure.
And in their points in limine, which is basically their legal points that they're raising pertaining to the founding affidavit of Dr. Nandipha. The first one was that it was in the format of an ex parte application, which means that there was no section wherein there should be a time. Okay, the way it is dealt with in motion court, if you're going to issue a notice of motion to your respondents, and especially under urgent application, you need to give them a time frame wherein they're supposed to file their replying affidavit. That was lacking in their notice of motion, which is a very crucial thing, because if you're not making it an ex parte application and it's a notice of motion, you have to give your respondents the opportunity to reply to the allegations against them. So that's the first thing that they raise. And then the second thing that they raise is that this matter is being brought to the court under an urgent basis. So that's the first hurdle. Second hurdle, I beg your pardon, that she will have to jump. If she can convince the court that her situation is indeed an urgent one, and urgent that is not self-inflicted. So in other words, she did not cause the situation that she finds herself in, wherein her right is being violated, whereas she could have dealt with this at some other stage and then dealt with it in the correct forum, but now she's choosing to put it in this forum, which is the civil court. So if she's able to somehow succeed in both these dilemmas, to make sure that she convinces the court that her papers were firstly correct and that her matter is indeed urgent, only then will the merits to the fray about whether it was an extradition versus a deportation, whether or not she was blindfolded, or whether or not she was unlawfully arrested, whether or not the Tanzanian law was applicable in this situation, how she was brought back to South Africa, wherein when she was handed over to the High Commission of South Africa, whether that was deemed for her to be on South African soil as per the papers of the sixth respondent in this matter. All of those things will then be dealt with. So she still has a few hoops to jump through before she can officially have her matter heard, and then it can be discussed based on the merits that have been raised so far.
All right, so I want to ask this question, and I'm trying to actually make sense of it myself in my own mind. In terms of, the fact that, you raise the fact that if she had been taken unlawfully and she, in fact, arrived unlawfully in South Africa to begin with, and she's able to prove that then means that she can get off on basically a technicality in that particular case, which then raises questions about the criminal charges, whether it is of abduction, aiding and abetting and so forth. The state cannot then bring back those charges now, can they, once she's been let off on a technicality? Does that then does double jeopardy then sort of kick in at that point, the fact that they cannot then bring back those particular charges? What then happens should she in fact find herself being able to get out on this technicality? What happens to those particular charges?
So let's say, for argument's sake, she's successful in the civil court. Because remember, this matter is being heard in the civil court, and it's running simultaneously with the criminal matter.
Right.
So if she's successful in the civil court, then the civil court does not have the powers to direct the criminal court on how they should deal with this matter. I believe that in the unlikely event that she succeeds tomorrow, then it means the civil court will have to remit the matter back to the criminal court and say, based on this evidence, on a balance of probabilities, we believe that there was the procedure in arresting accused number 4 was not done correctly, and therefore we request that the criminal court look at its own procedures and see whether or not this indeed is true. And if it is true, then the charges against the accused would have to be re-looked at and then be removed from her. Now, to answer your question about double jeopardy. If it so happens that she is successful and the charges are withdrawn against her, it won't fall under the umbrella of double jeopardy. Why is this? Because she first has to be found guilty or not guilty. So right now we're still in investigation stage. So the matter really is not trial ready. We're not attending trial. All we're doing now is just gathering information. And then once all the investigations are done and dusted, then the docket content is going to be given to the defense attorneys so they can prepare for trial. The moment that the accused persons plead, and this is whereby they plead not guilty and the trial starts. Should they be found guilty or not guilty in this matter, they cannot be charged again for the same crime. But if charges are withdrawn right now during investigation, they can be reinstated. So the state may provisionally withdraw the charges and then reinstate them again based on another set of circumstances or whatever the case may be. So it doesn't mean that it goes away from her. She will still will end up at some stage facing the crime at a later stage. Yeah.
All right. It was a pleasure talking to you. I wish we had more time. Thank you very much for giving us your time here on SABC News. That is, of course, our guest, giving us really the information of what we should expect, of course, with Dr Nandipha's application to the Free State High Court.